Hello friends, welcome. Friends, this headline is created a shock yesterday and drove Vodafone Idea stock price down from this level to this level, which you can clearly see that yesterday it was 8% down and today also it is almost like 4.56% down today, right? So this has created a lot of concern among the FPO investors who invested in Vodafone Idea stock, that what is going to happen to Vodafone Idea because SC, Supreme Court dismisses the telecom giant's plea seeking waiver of AGR dues. Now, friends, this whole legal tangle, which started in year 2003 till 2020, and even it is continuing right now, it's very complex. It is not easy for anybody to understand this in a short window period of time. So, friends, I took some time, to do some research and synthesize my thoughts in such a way that you will understand the whole issue, the whole debate, and the logical conclusion it can take, and how the DOT can bail out Vodafone Idea. Because I believe personally that this is not the end of the road. This whole SC dismissal is not at the end of the road. I found a headline which is from Money Control which has captured my thoughts properly. It says that a silver lining for telcos seeking AGR relief. And why this is a silver lining, I am going to explain to you in my video. Now, since this issue is quite complex and it requires a lot of understanding of subject matter which happened in past, and in order for me to do that, what I have done in this presentation, I put together a slide decks to anchor my thoughts sequentially. Not only I'm going to show you the bullet points which I have anchored in my slide decks, but I'm going to refer to the judgment, the text of the judgment, so that anybody who is watching this video will be fully confident that whatever I am telling you is laced with facts. And this is not just I have made up from myself. Everything that I'm going to tell you is going to be linked with facts and is going to point to the original document. So friends, what I want to do without wasting any further time, my presentation today is the title of my presentation today. And let me just do a little bit of, this is current. Who is responsible for AGR fallout and saving Vodafone Idea? So there are two issues which I'm going to discuss in this presentation. Who is responsible for AGR fallout and how we can save Vodafone Idea? So we have to understand that this is an institutional failure. These are institutional failures, because when you look at my presentation and you go through my arguments, you will find that this thing could have been avoided very easily, right? It is such a sorry situation, friends. You will not understand. The objective of the whole AGR total revenue was to prevent litigation. It did exactly the opposite. It created a litigation which lasted for 20 years. Can you imagine that? The intent of aggregating the whole revenue, telecom and non-telecom, the purpose was to avoid litigation. And that is why I call it institutional failures. A series of institutional failures. And that's why who is responsible for AGR fallout is important to understand. Why it is important to understand who is responsible for AGR failure? Because in the institutions, Supreme Court, DOT, operators, regulators all have responsibility, and they may not be technically, it is not possible for them to technically help, but morally they are responsible. And let me explain to you why they are morally responsible, and that I believe will open the pathway for saving Vodafone Idea because of this moral responsibility, and one needs to understand why they are morally responsible. So let's first do a introduction. Why this debate matters now. Vodafone Idea is on the brink. Everybody knows that they have to pay in this year, this financial year, end of 2026, 31st March 2026, they have to pay 18,000 plus crores, which they can't pay. They have already conveyed this to DOT in their letter, right? And that is why this issue is being discussed. So SC has refused relief and DOT claims helplessness, because when the letter was written by Vodafone Idea to DOT giving them this relief, DOT said that we can't do anything because the Supreme Court judgment prevents us from giving you any relief. But actually there are three parties involved: Supreme Court, DOT as well as the TSP, which I'm not going to focus in this video much because I believe operators are also responsible, but I am not going to focus the operators responsibly in this. I'm going to focus on both SC and DOT responsible and for the current AGR crisis. And how they are responsible, this is not just something which I'm making it up. You yourself will be able to tell when I am going to take you through the facts. So any resolution must acknowledge shared responsibility. So technically they may not be able to help. Supreme Court may not be able to help. I understand why Supreme Court may not be able to help, because all judicial intervention and all judicial processes have been exhausted. There is no way Supreme Court can help. But Supreme Court can remain passive. And that is what is very, very important. And why it is important for Supreme Court to remain passive, you will understand as I take you through the slide deck. So this deck will walk you through who did what went wrong, and what can still be done right now, which we will discuss. So DOT's role, policy ambiguities, and poor consultation. Now, friends, DOT in the migration package left the definition of AGR vague in 1919 migration package. I am going to show you the migration package so that there is no confusion and people can pause the video and understand and read what the government said. So here I'll say, here, if you look at this, and let me just do a little bit of, it'll be good. So what it's saying is, the gross revenue for the purpose would be the total revenue of the licensing company, excluding the PST and blah, blah, blah. And then it says that on receipt of TRA recommendation, and the government final decision, final adjustment of provision dues will be affected depending upon the percentage of revenue and the definition, etc., which will be decided later. So what I want to tell you is that DOT kept the definition of AGR vague, and it wanted a TRAI consultation. It is important. So TRA consultation is done with the purpose that all stakeholders will be able to contribute. DOT will take an informed decision, right, by application of mind. It is not going to be a decision without any consultation, and therefore they left it for TRA to decide, and therefore TRA consultation process should have been given weight, right? And then DOT can take his own decision based on what TRA has recommended. So this is very important, the migration package, right? So they kept the definition of AGR vague, and operator signed a vague definition of AGR when the contract was signed, knowing pretty well that justice will be done because TRA consultation will give them a process to create a definition which is in line with everybody's interest. Okay, so that's the whole purpose. Then what happened was DOT rejected TRA views without giving any explanation. So this is unwarranted, because whenever there is a consultation which is happening within TRAI, this consultation is not done just because of academic purpose, right? We are not feeling, good just by doing a consultation. The consultation is done so that the views of party can be collected in one single place, and DOT will have the opportunity to look at all the parties' comments and then take an informed decision, right, loaded with all facts, so that it will be in the interest of every stakeholder, including the government, right? But it rejected it without assigning any reason. And how do I know that? If you go to the back reference of TRAI, you will see that revenue share definition, DOT's comment, the government proposed to follow a definition of adjusted gross revenue for the purpose of computing license fee, which is different from the definition recommended by TRA, but it did not give any kind of explanation. So if there was a different definition and the TRA gave a different definition, then why the government did not come out and say that why their definition was different? You understand what I'm saying? They should have explained at the beginning itself. And this was a document dated what? Let me show you the date of this document. This document was dated 31st October 2000, right? Which is almost like 25 years back, right? Imagine this. So DOT's comment says that we reject it, but we will not give you any reason, right? So this is not the way the policy should run. But what is the purpose of having a consultation with TRA, right? Then there was a consultant which was hired by DOT to feed them with information, and there was a parallel consultation which was going on in TRA. Now, if DOT wanted to hold a separate process, right, by having a private consultant give them separate feedback which is hidden from all the stakeholder, then what is the purpose of having a consultation with TRAI, friends? So this consultant report, which DOT received in parallel to the TRAI consultation which was going on, was not made public before TRAI, so that everybody could have seen what the consultant is saying to DOT and what basis the definition of revenue was decided. Then the TDSAT on 7th July found that the consultation which DOT held with TRAI was non-compliant with the TRAI Act. And this is pretty important, right? Let me show you. This is what the TDSAT is saying. In view of the fact, we have come to the conclusion there has not been any effective consultation with TRAI, which is mandatory under the TRAI Act, right? We think we should not further delve into this exercise, finding out which component of AGR as defined by the government on the condition, because there has to be a consultation. Now, after 7 years, the TDSAT finds that there is no effective consultation. And I'll tell you, friends, upfront, before we go to the next slide, this issue of not holding an effective consultation with TRAI, and that became one of the major cause of delay, was not dealt with in Supreme Court. Because Supreme Court, when it started evaluating this whole issue, they were evaluating, various questions of law. But how can DOT reject a TRAI consultation without assigning any reason, which was caught by TDSAT? TDSAT is also a judiciary body. So we expect the Supreme Court to look at this issue, that how can DOT reject TRAI recommendation when, as per the current framework, we have TRAI who is holding a consultation with a purpose. DOT may have their own reason of rejecting it, but they have to cite that reason, right? What reason that they are considering for rejecting TRAI recommendation. I'm not saying that DOT doesn't have power, but reasons have to be cited, right? So there was a failure of overall consultation process. So DOT reversed its prior stand on August 2011 affidavit of excluding non-telecom revenue. And this is shocking, friends, because DOT never wanted the full revenue to be included and you will find that even the consultant also never recommended that the total revenue should be included. And you probably will not be aware of this, and I'll show you the affidavit of DOT, and you will find that, very, very interesting. So this was an affidavit which DOT had filed, right, before, I think, TDSAT, on dated 11/8/2011. And I'll read out the language of this affidavit to you. So it says, during the course of the hearing, Mr. Soli Sorabji found the Learned Student Council placed on record the following stand of DOT. Department stand is that the revenue from non-telecom business, which is entirely different from telecom business of the licensee, is not included in the definition of GR. This is also as the consequence of maintaining separate accounts. So when DOT makes a statement, right, before, I think it is TDSAT, right, So on 11th of August 2011, and saying that if you separate the revenue, we will not consider that as an integrated. This is the Council of DOT making a statement, and DOT in 2021 separates these two things together, altogether. Telecom is separate, non-telecom is separate. So if this was such a serious issue, right, where integration was so important, why first the DOT's council made a statement before the court like this? And why in 2011 DOT chose to segregate these two compartments separate, and now license fees charged on only the telecom portion, not the non-telecom portion? Don't you find it very contradictory? And it was like a hypocrisy. If this issue was such an important issue and it was done with the purpose of preventing litigation for such a long period of time, and then later you reversed it, means you could have very easily taken a very lenient stand in the beginning itself. Why wasted so much amount of effort, time, money in fighting this case in the Supreme Court or in various other courts in India? It makes no sense. It clearly shows that there could have been separate accounts which could have been maintained, and this issue would not have been raised in the beginning itself, right? Now, let's go to the next slide. SC's roles missed jurisdiction and harsh interpretation. And this is the responsibility of Supreme Court. Let me point out. What Supreme Court did is, when Supreme Court didn't settle TDSAT jurisdiction in 2007, when TDSAT gave a judgment and said that, look, the non-telecom and the telecom portions have to be separated out, the matter went to Supreme Court. Supreme Court said that no, you go back to TDSAT because there is a TRI consultation process which is going on, and DOT you go and start to present before TDSAT all that you have done in past when the TDSAT came out with this judgment, right, which was challenged in Supreme Court, because there was a legal process which took place in TDSAT where DOT lost and the matter went to Supreme Court. Supreme Court said that, okay, nothing doing. Whatever happened in past, you go and re-agitate those cases, those points again, right, before a TDSAT, and did not clarify the TDSAT jurisdiction issue, which it clarified later, right, in the 2011 judgment. So 4 years were lost. And then what was the point in re-agitating all those which TDSAT settled? The TDSAT said that, look, I have already settled all those issues. Now SC cannot ask me to re-agitate all those issues again, right? Which makes no sense. I have been wasting time sitting here or what, right? So that was the legal, you can say, conundrum. It's a very, very, I do not understand how this whole system functions. I am not questioning the integrity of the process, but the process is become so cumbersome where so many parties are involved, these things fall between the crack. And then what happened? OSPI's judgment of 11th November ignored the scrutiny of DOT's rejection of TRA advice without assigning any reason. Because what happened, if you look at this prayer, right? This judgment of 2011 of Supreme Court. So what Supreme Court said? Supreme Court said that there are substantial questions of law which needs to be investigated. And when it went on to investigate substantial question of law, there were many points which you can read and pause the video and read or go to the judgment. But it did not investigate this point that how can TRAI reject, so how can DOT reject TRAI's advice without assigning any reason, which TDSAT pointed out as an important, failure on part of DOT. And that's why, there's so much amount of time elapsed. And that was one of the reasons why TDSAT ruled in favor of the operators. Right. Then in 2019 and 20, SC ignored the lenient stand of DOT in the 2011 affidavit, which I told you. This is the affidavit, right? Where it says that we can separate the revenue, DOT's counsel is telling the court, right? Then if you go up again, let me just go again. And then SC order of September 2020 rejected the 20-year payment proposal. Now, SC now is saying that DOT can do whatever they want. But when DOT went with a modification application, and let me show you the modification application. This is the DOT's modification application where DOT is saying that there be an annual installment after the 2019 judgment of Supreme Court where they rejected the operator's plea. They say, okay, we will basically, do a 20 years, period of payment with 8%. But Supreme Court did not agree to that. They made the payment condition much more harsher. Right? So they rejected it, and instead of having a 20-year period, Supreme Court said that the 10-year period and 31st March 2031 was the sunset date. So what was the point in when Supreme Court coming out with a harsher judgment when DOT, which was actually one of the party to this litigation, themselves are offering to give a relaxed, payment condition, citing all the difficulties that they are going to face on account of reduced competition. So Supreme Court should not have intervened, right? Because it was a contract between two parties, the government and the operators, and the government is a responsible party acting in the larger interest of the people. So there was no need for Supreme Court to change the payment condition. Then clause 38 bar reassessment. Now the point is that if you look at the Supreme Court judgment here if you see, these are the final. Resultantly, we issue the following direction, right? We say that there shall not be any dispute arising by any telecom operator and there shall not be any reassessment, right? And then it goes on to give, what should be the payment condition and blah, blah, right? My question is very simple. If there was a demand which was issued by DOT, Supreme Court knows that when a demand is issued, there could be some errors which can be committed by DOT officials because DOT officials want to come out with a demand which is a little bit more expansive, given the fact that if they make any miscalculation, then they will be liable for causing loss to the exchequer. So there could be some double counting, etc. So reassessment should have been allowed. Now I can understand why Supreme Court prevented a reassessment, because Supreme Court thought that this battle has been lingering for years together, and operators are always finding a way to wiggle out. And that is why, friends, in the beginning part of my presentation, I told you that TSPs are also responsible, because TSP should have done something to cause this battle to get over soon. They were too complacent. And that is one of the reasons why the judgment of 2019 and 20 was so harsh. Because the Supreme Court said that, look, you guys, right, are big companies with so much amount of money in your pocket, and you are creating so much profits, and you're enriching your shareholders, and now you're fighting a 20-year battle then after having agreed to the contractual terms, and now don't want to pay. So DSPs, there are many things to talk about here, friends, and I don't have the time, and I can come out with a separate video and I'll tell you why TSPs were also responsible, because of narrow, thought process of litigation. Because whenever you have such long litigation, you can't control the litigation. There will be some kind of schism or some kind of things which will fall between the cracks, which are not going to be in your control. This is exactly what happened in this case, right? So what is now? Let's come back. So this is the point which I said: barred reassessment of preliminary dues, and penalties and interest and penalties upheld, right? In spite of the fact that there was so much delay which was caused by the court. Supreme Court, did not look at the jurisdiction. TDSAT came out with a clear-cut, understanding of their order that DOT did not follow a due process of TRI's consultation. So DOT did not follow TRI's consultation. TDSAT came out with a judgment clearly attributing the failure on part of DOT. And then Supreme Court, passed the baton back into TDSAT without, looking at the jurisdiction. And later in 2011 judgment looked at the jurisdiction. So much time has been passed because of this, back and forth between adjudicating agencies. So then there was no question of penalties and interest. Another thing which I would like to point here, penalty is what? Penalty is not compensatory. Penalties are always with a purpose to prevent somebody to act in a manner which he or she has been acting. So in this case, if you look at in 2021, the battle which took place for such a long period of time between telecom and non-telecom revenue, DOT came out with an order saying that we are okay with, the license fee calculated on the telecom portion of the revenue. So if that is so, then what is the point of having penalties? Because you yourself have changed what you have been fighting for such a long period of time. And you're saying that we are okay with collecting revenues on non-telecom portion. So VI's petition is strategic framing with legal limit. Now you can understand that when you run a litigation for such a long period of time, these kind of pitfalls will happen. You cannot avoid these pitfalls, friends. And these pitfalls are nobody's fault. It is a system, the judges are so busy, they will not read the full document. They will just simply pass it on. And then when it comes back, then only the whole thing will be scrutinized. So it is the responsibility of the parties, both DOT as well as the operator, to settle this amicably as soon as possible, not to extend the litigation for a long period of time. This is the sorry state of our situation in the corporate world as well as in DOT. So VI's actually position was quite constrained. It could not have asked to remove the 2020 bar on reassessment. It could not, because review petitions were rejected. It would have basically meant to have a review, right? It would have meant review of the final judgment. So VI rightly limited its prayer to waiver of interest, penalties, and interest on penalties, citing writ petition on different grounds. Then the grounds were different, which I already spoke about in one of my videos. No interest on installment deferred. Alternatively, request DOT to consider their 17th April 2025 letter, which was a letter where they were seeking a different form of payment condition or something else, which VI themselves will know, right? So the framing respectfully the legal finality of SC's 2020 judgment, avoiding rejection on technical. Otherwise, this would have got rejected in technical grounds anyway, friends. If VI came out with the pointing out through those failures, which I'm pointing out right now, SC would have rejected it because they have already rejected it, the curative petition. The curative petition I have already spoke in one of my videos. that the whole purpose of curative petition is to remove these errors. Now, when the curative petition has been rejected, you can't have a separate curative petition. It's not possible. Technically, it is not possible, right? So we are actually a victim of circumstances, technical issues. It is not justice. Justice can never be done in completion. If you want justice, the people who are seeking justice also have to behave responsibly. And here, they did not behave responsibly because they did not force a closure of the issue quickly. They kept on litigating forever, right? So, why dismissal may be an opportunity for DOT? And this is very, very important. The SC's dismissal or VI's petition, but orally stating that DOT is free to act. Because I told you, in past, whatever DOT tried to do before SC seeking a modification of the order, in citing, public interest, SC said no, nothing doing. They are not going to modify the order. They say DOT seeked a larger duration of payment. SC said nothing doing. And there are many things which SC did not agree to DOT, where DOT themselves wanted to give some relief to the operators. I don't want to get into that because this video will become 1 hour. If I go in point by point, you will be surprised to know that DOT really wanted to help after having reconciled to the fact that they have actually gone too far. But SC said nothing doing, right? Nothing doing. So how could DOT have acted? DOT had no other option, right? To be passive, and they were within their right to tell Vodafone that they have no control of the situation. Now, this is an opportunity. This is dismissal opportunity because now SC is saying that DOT is free to act. They never said in past. They opposed each and every DOT's decision or only gave partial relief. While SC won't intervene further, it's an ORO stand opens door to DOT. This is very, very important. Since SC refuses to become a party, DOT can act without fear of contempt. Because there was a clear mention in the 2011 judgment, if you see 2020 judgment, that if you look at here, and I'll show you, beside it will be punishable by contempt of court. Nothing you can do, not even a rupee change, and everything has to be paid in time, and there has to be compliance reported by all TSP and DOT 7th April each succeeding year. So you can imagine the kind of scrutiny and kind of control SC is exercising. So when SC says that DOT is free to act, then this compliance every year, SC is monitoring, right? So Supreme Court is fully monitoring the payment of AGR, and DOT has to file a report 7th of April every year, right? So it is not that, DOT was free to act. It was a complete control Supreme Court was exercising because of the 2020 judgment, right? Now, what DOT can do now, realistically, lawful actions. DOT should not seek a review because in a technical terms, if you see, there is no option left for seeking any review. Because all review has to be sought under certain framework, certain other judgment. And all those have been already tested legally and failed. Whatever reason may be. And I will not like to get into the reason because I'm not a lawyer. So I really don't know. So DOT cannot seek any kind of review now. So that would have required SC to open the settled questions in law. It will be a long drawn process because each and every clause have to be reviewed. You can't come out with a judgment in just a matter of few days. It will take another year. It may go for another 2-3 years. God knows. Instead, DOT can grant waiver of penalties and interest under its policy discretion. Because Supreme Court is now saying that DOT is free to act. Now, DOT can go and take some kind of step, right? And test it. What will happen? Supreme Court will call them. Why you have taken this step, right? This is exactly what happened in 2020 when DOT's official told those finance guys, please not to do any coercive action, and Supreme Court called up the DOT official and said that this will be contempt of court and you'll go to jail. So let DOT make an attempt, right? At least make an attempt and see what SC does. So it can do what? It can give a waiver of interest and penalties or offer a long-term payment schedule. Let's say 30 years or 40 years. It will reduce that 18,000 crores of rupees to, let's say, 4,000 and 3,000 crores. That is a very easy thing to do. Make it long-term, right? And because nobody will accuse you. If you make it long-term, it will be NPV protected. So there will be no problem. So this route aligns with the SC's oral position, avoids judicial overreach, and any DOT action as and it will be seen as pro-competition and sector saving and unlikely to be challenged in by in Supreme Court. The final message: the window is narrow but real. VI has to be saved, friends. It has to be saved, and DOT has the responsibility because of all the inactions which I have told you, and what kind of policy failures that DOT have undertaken since the beginning, right? Supreme Court is also responsible, and therefore Supreme Court has, it may not be technically possible for Supreme Court to intervene here, but they can be passive. Very, very easy, because Supreme Court themselves were responsible. Nobody's reading those texts, right? It was when the petition was dismissed, the Supreme Court never read it. It just went through the prayer and said that how can a multinational company ask for waivers of interest when it is making loads of money? So unless you go through the whole petition and see who has done what, then only you will come to know what happened, because judges will not know each and every case. So there was no way Supreme Court have read the full petition and take a judgment, right, on whether it has to be dismissed or not dismissed, right? So there was no way. So therefore the courts have a moral responsibility now, and if DOT acts and tests the waters of the courts, and if the court says nothing doing, then they'll reverse back, just like what happened in past, right? So the final message, and the window is narrow, what I'm saying is, because VI will collapse, it will lock spectrum, destroy value, trigger a duopoly. I already did a video where I explain how much amount of spectrum will get wasted, right? How much amount of destruction it will cause to India's interest. It will hurt the consumer, not 200 million, the whole ecosystem of consumers are going to be hurt, because there will be no leverage left. It will be mercy of two operators. Parliament route will be slow and politically sensitive. Judicial review is barred. And only viable solution, friend, is DOT should act now, confident that SC won't block them. And even if SC blocks them, that will give an opportunity to discuss this case in the court. Let's say DOT comes out with an order and SC says this is a contempt order, right? Nobody will be going to jail. It never happened in past. It can be reversed, right? DOT say, okay, I will reverse my order. I'm sorry. Okay, that's all it will happen. So this can be done very easily, friends. And Supreme Court has made a statement. So provide relief in public interest to secure India's telecom future. So friends, net, this is a half an hour video. I could not have done it in 20 minutes, friends. Sorry for that. It is such an important topic to understand. So everybody should watch this full 30 minutes video, friends. Otherwise, you will not appreciate, what opportunity. See, VI has got a golden opportunity, and therefore I am telling you that this headline, which has been done by Money Control, a silver lining for telco seeking AGR relief, is the headline of the day. I see a silver lining because DOT has got nothing to lose. You make an attempt and let the Supreme Court say that, this is violation of the order and we are going to issue a contempt, and you say that, okay, we are sorry because we understood that you actually wanted us to help. So we tried to help. And now since you don't want to, we will reverse the order. You understand, friends, how the opportunity, this is an opportunity. So this petition of Vodafone Idea in the Supreme Court is not a wasteful attempt, friends. Many of you might be thinking it is a wasteful attempt. To me, it is not. Given the background of this case is too complicated, friends. So anyway, I hope that you have understood this case clearly and what opportunity exists, clear terms, because unless I have spent half an hour, 33 minutes to explain this, it is not possible to do justice to this complex topic. I am very thankful for friends listening till the end, and let me know your comments and what you think in the comment section. And if you have any other request to make, please let me know, and I'll come back with a new video on a new topic next time. Thank you very much for listening till the end.